Zoom.us.
Yeah, well, I'll have to let her. I'm on an iPad and it looks a little trickier. So
Your time is up. So
okay.
okay.
Darlene, he doesn't like the name.
Yeah, Darlene, we had a Bruce, Representative White has a name issue.
Great last name.
Oh, did I give him a different name?
Yeah, Representative Bryant hacked into my account.
Oh, no. Okay, you hold on just as soon as the
Okay,
Brady
Bobby.
Bunch comes back on here, I can switch and we can go.
Yeah.
All right. You ready
Thank
to
you.
roll?
Okay, very good. Good afternoon, everybody. Welcome to the Transportation Committee public hearings. We look forward to having you with us today. We'll be hearing 5 bills today, and we will, before we start though, we want to just remind everybody, this is our electronic meetings we're having, so please be patient with us. We're doing really well, I think, and our clerk Darlene has been wonderful and helped us through a lot of issues, but be patient with us. The meeting is being live streamed on the committee's YouTube channel, and all participants via Zoom can be seen and heard. If your mic is on, testifiers cannot be seen or heard until they are recognized by the chair. The meeting is also recorded and available on the committee's YouTube after the meeting is concluded. Remind everyone that be sure to make sure your name is displayed correctly. Representative White, thank you. And the same as you've registered. And also remember that to the committee members that the use of Zoom chat is not for anything of substantive nature. Public hearing process will be starting with the sponsor, of course, followed by the co-sponsors if they're here to do that, followed by the public based on the registration that you have given. For example, we always start with those who are proponents, followed by those who are opponents, and followed by those who wish to speak neither for nor against. When called upon, you will be promoted from attendee to participant, and when finished, be returned to attendee status. And when called upon, make sure your mic is unmuted. State your name, your residence, and if you have any affiliations, please be sure to mention those. All individuals who wish to testify must register in advance of the public hearing in order to be called upon to testify. If you're using a video, you will be sent an attendee invitation to the Zoom webinar via email. If testifying by phone, you will use the Zoom toll-free number associated with this meeting. Remember, everybody, if you've not been to a public hearing before, only committee members can ask questions. We're going to now ask the members to introduce themselves. I'll call upon them, and then we'll hear who we all are. We'll start with Senator Farren. Good afternoon, Senator Farren.
Thank you, Mr. Chair. My name is Brad Farren. I live in Norridge Walk and represent the majority of Somerset County in one town in the county of Kennebec, Rome.
Thank you, Senator. Senator Ben Chipman.
Not here yet.
He's not here. It's followed by Representative Wayne Perry.
Good afternoon, everyone. My name is Wayne Perry. I represent House District 10, which covers Arundel, Dayton, and most of Lyman. Thank you.
Thank you, Representative Perry. Representative Lynn Williams.
Good afternoon, everyone. I'm Representative Lynn Williams. I represent District 135, which is Bar Harbor, Lemoyne, and Mount Desert.
Thank you. Representative Mike Perkins. Excuse me, Representative Dustin White. I'm sorry, Dustin.
Not here.
Not here. Okay.
Not here.
Representative Mike Perkins.
Good afternoon, everyone. I'm Representative Mike Perkins. I represent District number 77, Oakland and Sydney.
Thank you. Representative Mark Bryant.
Thank you, Senator. I'm Representative Mark Bryant. I represent House District 24, which is part of the town of Wyndham.
Thank you, Mark. Representative Bruce White.
Hi, yes, I'm Representative Bruce White, and I represent District 109, and that is half of the Waterville area.
Thank you very much. Representative Tom Martin.
Not here.
Not here. Representative Kevin O'Connell.
Thank you, Senator. My name is Kevin O'Connell. I represent District 128, which is the majority of the city of Brewer.
Thank you, Kevin. Representative Rich Sebra.
Thank you, Senator. I'm Representative Rich Sebra, accompanied by the junior senator from Naples here, my grandson Edwin. District 68, lovely towns of Naples, Sebago, Baldwin, Cornish, and Parsonsfield.
Thank you, Representative Seaver, and thank you for bringing along that wonderful junior senator. Representative Danny Martin, House Chair of the committee.
Thank you, Mr. Chair. Danny Martin, representing House 150, located in northern Aroostook County, and a proud member of this committee.
Thank you, Mr. Chair. And I'm Senator Bill Diamond. I represent Senate District 26. I live in Wyndham, and my 6-town circle Sebago Lake, except for Fry Island, which is in the lake. Again, thank you very much. We also have introduced our analyst, Sam Prowler. Sam? He's here, I know he is. Also, Karen Neto, and our clerk is Darlene Semino. So thank you all for all you do for us. We appreciate that greatly. Also want to, again, talk about the order. We'll be starting today with LD 228, excuse me. And we will open that public hearing now. LD 228, an act to allow travel in a center lane of a restricted highway, presented by Senator Carney of Cumberland. Good afternoon and welcome, Senator Carney.
Thank you. Good afternoon, Senator Diamond, Representative Martin, and esteemed members. I'm going to adjust my screen a little bit. The image is a little strange. Well, that's no better. Esteemed members of the Joint Standing Committee on Transportation, I am pleased to appear before your committee for the first time today and eager to introduce LD 228, an act to allow travel in a center lane of a restricted highway. I appreciate you accommodating my schedule. I plan to stay for the entire hearing on LD 228, but I may have to step aside for literally 1 minute to cast a vote in a judicial nomination hearing. LD 228 amends existing law to allow motorists to use the center lane of the main turnpike as a travel lane. When I explain LD 228 to my legislative colleagues and others, they scratch their heads and say, don't we already do that? Indeed, one of the opponents of LD 228, the Maine Motor Transport Association, echoes this reaction in its testimony, and this is a quote from their testimony. I know that many of you frequently travel on the main turnpike. You are likely thinking that regular travel is already legal in the center lane because it is a common practice to see cars routinely traveling in the center lane, even when not passing. You would not be alone. And that's kind of the point of LD 228. The current statute is quite clear. It reads, an operator driving on a limited access way with a speed limit of 65 or more miles per hour is restricted in ordinary operation to the right-hand lane and may use adjacent lanes for overtaking and passing another vehicle, but must return to the right-hand lane at the earliest opportunity. This current statute is not how drivers use the 3-lane portions of the main turnpike. The center lane is a relatively recent phenomenon in the life of Maine drivers. Construction of the turnpike began in 1946, and the first section opened in 1947. It wasn't until 1970s that the first 12 miles of the turnpike expanded to 3 lanes in each direction. In 2004, the Maine Turnpike Authority expanded the 3-lane portion through mile 44. The Maine Turnpike Authority's 2020 capital program includes expanding the 3-lane portion to mile 49. I was not able to find data on the percentage of drivers who violate 29A MRSA section 2052-6 as currently written, and I think it would be challenging to compile the data based on my observations and the comments I hear about LD 228. However, many, if not most drivers on the main turnpike use the center lane as a travel lane. In fact, it is so consistently used in that manner that I think it would be difficult to truly measure the impact of LD 228 if it were implemented, because this bill defines the existing use of the center lane on the main turnpike. I appreciate that others may raise safety concerns about eliminating this restriction, and I have a sincere respect for the Maine Turnpike Authority and members of the Maine State Police who patrol the busy 3-lane portion from mile 1 to 44. Travel in the center lane is so prevalent, though, that passage of LD 228 would not create a change in traffic patterns. I also appreciate concerns of the trucking industry that LD 228 will prevent trucks from using the center lane to pass slower traffic. I want to clarify for the committee that LD 228 does not address restrictions on truck drivers. Currently, trucks are restricted from using the leftmost lane between mile 1 and 44 by the Maine Turnpike Authority rules, which read as follows: lane restrictions. In order to improve the air quality in southern Maine, trucks, including tractor trailers, but excluding pickup trucks, all is defined, and then it cites the section of the Maine law, may only operate in the 2 furthest right-hand lanes on any section of the turnpike south of mile marker 44 that consists of 3 lanes in each direction. So that's the turnpike rule. It's not a matter of state statute. When the turnpike expanded in 2004, Maine was in non-attainment for EPA air quality emission standards. That has since been addressed and we are in attainment. Restricting trucks from the left-hand lane back then reduced emissions by reducing the speed at which trucks routinely travel. The Maine Motor Transport Association points to a plan to allow trucks to use the leftmost lane when mile 44 to 49 expansion is completed. They suggest it would be safe, efficient, and fair to allow trucks to use the leftmost lane for passing along the entire 3-lane portion of the Maine Turnpike. Those are important considerations, but they don't need to be resolved in order to pass LD 228, because the current traffic pattern already comports with the language of this bill. Thank you for your time and consideration this afternoon. I urge you to vote ought to pass on LD 228, and I'm happy to answer your questions.
Thank you, Senator Carney. We appreciate your testimony and presenting the bill. Senator Carney, I have to leave to go to a confirmation hearing at the moment, so I apologize.
I understand that.
And I will turn it over to the House Chair, Representative Martin. And I think questions are now in order. Thank you.
Thank you, Senator Diamond. Are there any co-sponsors who wish to testify on LD 228?
The only co-sponsor is also in the judiciary nomination hearing.
Right, thank you.
Danny? Representative Kinney just hopped on. She'd like to testify on this bill.
Representative Kinney, go ahead.
I'm on, there we go. Thank you. I guess Senator Diamond has left, and Representative Martin. I am Representative Mary Ann Kinney, and I represent House District 99, which are 9 towns in Western Waldo County. I'm actually in the meeting today because I have a bill that'll come up a little bit later, but this one is interesting to me. And I had spoken with Aaron Courtney with the Maine Turnpike Authority, because I have a bill that addresses the trucks in the left-hand lane as a truck driver myself. Which you'll get that information. You'll hear all about how I was a truck driver for
I'll
quite
just
a
be
while.
very honest, sir. I run and own 3 businesses.
Sorry about that. The Maine Motor Transport is concerned about this bill, and rightly so. And with my conversations with Aaron Courtney, my bill might be able to help address the issues, and it might be something that we wait until I am working with the revisor's office right now on language for, and I'm trying to remember what the LR, I don't have an LD number yet, but I have an LR number. That's not what's on my phone. And so once that comes forward, that may be something that'll be more helpful, because it would absolutely be a safer thing if the trucks are allowed to be in that left-hand lane. But I'll save that testimony for my bill. Just something to think about that is coming down the road as far as this bill is concerned.
Great. There are questions from committee members from either the sponsor and the co-sponsor, or for people testifying.
Yeah, I do have a brief question, Representative Seaver from Naples.
Go ahead, sir.
Yeah, so I'm just a little confused by the bill itself. You're referring to lane number 1, which is how the lane that is closest to the center divider in either direction would be designated. So you're talking about lane number 1, not the center lane of a 3-lane highway, because you could define a center lane as the lane closest to the center or the division of the highway from, say, in our case, north and south, or the center lane, which would be the middle lane number 2 between lane 1 and 3 in a 3-lane highway. So you're talking about lane number 1, the lane closest to the divider on a multi-lane highway, correct?
I don't know if the question is addressed to myself or Representative Kinney.
Go ahead.
Whoever's got an answer would be great.
So since I'm sponsoring the bill that's being heard, I'll just answer that I adopted the same naming system that is used by the statute and also by the Maine Turnpike Authority rules. And they refer to the rightmost lane, which as you're driving would be the lane furthest to the right, close to where the on and off ramps go. And then they say the center lane, which would be between the rightmost lane and the leftmost lane. And then they also talk about either the far left or the leftmost lane. They kind of use both of those, but that quote leftmost or far left lane is the one that would be closest to the oncoming traffic. And so the bill relates to currently the rightmost lane, the one that's most adjacent to the on and off ramps, is supposed to be the travel lane exclusively, and the center lane and the leftmost lane are supposed to be for passing. And what LD 228 would do would be to say that you could travel and not be pulled over for a violation of the law if you were driving in either the rightmost lane or the center lane of the 3-lane highway. And that is kind of in effect the practice that most drivers adopt on the highway. Does that answer your question?
You all set, Representative?
Thanks.
Great. Others wishing to testify in support of LD 228? I see none on my list. The chair will now take those who might be in opposition to LD 228. And on my list, we have Director Peter Mills, Tim Doyle, and I believe Lieutenant Scott. Director Mills, are you available?
I am. Can you hear me?
We can.
Yes, Mr. Chairman and other members of the Transportation Committee. I'm the Executive Director of the Maine Turnpike Authority, and I've held that position for about 10 years. It's true that we do have, we are authorized by law and we do by rule have a prohibition against trucks using what we call lane 3, which is the one next to the median, the far left-hand lane, which does tie into this bill, because if you pass this bill and the center lane becomes usable for non-passing vehicles, for vehicles that are simply traveling along at the same speed roughly as the people to their right, then it leaves no opportunity for truck drivers to pass. So the system as it's envisioned by those who have produced the statute in the first instance, and then the rule that was adopted many years ago, back when the widening occurred, the current, this is, by the way, Maine's only 3-lane highway is on the turnpike. There's a little bit of 295 that I think has 3 lanes, but basically we're talking about the mile markers from mile 0 down at the bridge to mile 44 in South Portland. There will be more 3-lane highway as we complete the widening around Portland, but for the time being, it is 0 to 44. And the rules that apply to that stretch, and they're well known by the trucking industry certainly, are that the driving lane is the extreme right lane, that the middle lane and the left lane, far left lane, are passing lanes of one sort or another. theory being that you would be going somewhat faster if you were in the middle lane or in the left lane. If you are a truck, you are relegated to the two right lanes. You can travel in the extreme right lane. If you need to pass, you have the middle lane in which to do that. So that's the system. When you begin to pass new rules or new legislation affecting those usages, you need to look at the whole thing. Just as Representative Kinney suggests, and she's a trucker, and she's saying you got to look at my bill as well. And we would suggest and agree with her to this extent that you ought to be looking at the whole thing. And we will accept, whatever you decide, we will certainly accept your guidance and your laws. But you do need to look at the whole thing and evaluate what is the most appropriate and safest system to be operating a three-lane divided highway of this kind. One of the reasons, so I'm going to jump ahead to why we're keeping trucks out of the left lane, because Representative Kinney raised the issue, and it's kind of central to why we need to keep the center lane as a passing lane. But we keep trucks out of the left-hand lane because they're pretty close to oncoming traffic over on the other side of the median. Many of you are old enough to remember when the median had no guardrail. We just had a big, deep lawn, basically, that ran the 18 feet between southbound and northbound. And I remember as a young trial lawyer seeing really tragic accidents involving people moving from one direction to another and coming into head-on collisions at equivalent speeds of 120 or 140 miles an hour. They were horrible. We have installed guardrail on the median everywhere, and we spend a lot of money maintaining that safety measure on the 44 miles of road south of Scarborough and South Portland. It is, however, possible for a truck, particularly a loaded truck, to get through it. And I have seen it happen during my tenure here at the Turnpike. I have seen fatal accidents caused by a truck that, for whatever reason, veers left and manages to penetrate the guardrail and get over onto the other side, and it raises havoc. So it is safer, generally speaking. I think the engineers would agree with me that it is safer if we do ask the trucks and direct the trucks to stay on the center lane, in the center lanes, and the right-hand lanes, preferably in the right-hand lanes for travel, because then they are right next to the outside. So that's the system we have. We can discuss it. You can ask that it be changed. We will accept your guidance, certainly, but I just need to make sure that everybody understands the rationales behind the current structure of the law and the rules that are in place. That's really what I'm here for.
Great. Thank you for your testimony, Director Mills. Representative Perkins, you have a question.
Yes, I do. Thank you, Chairman. If this isn't going to change the traffic pattern, then why are we instituting a law or a new rule or a new law? And Mr. Mills, I just want to make sure, comment, I have driven many, many, many miles up and down the road with a tractor trailer truck. And a lot of times that third lane over there in the middle lane helps the drivers maneuver up and around, realizing we're not supposed to move that third lane, but it also gives the drivers an escape path. And I don't think that we should be changing anything. Thank you for your time.
Well, I'm sorry.
Go ahead.
Okay. Well, the law, I'm sorry, if you don't change anything, you would be living with the existing set of rules. And the existing set of rules are the trucks are forbidden in the extreme left lane. That's the rule. And of course, they can go there in an emergency, and they do. And it is, for all practical matters, it is there in case there's something that happens up in front of you and you need to veer left. It's a safety measure, certainly. But the general rule for operating vehicles is that the center lane is fundamentally a passing lane, a lane for people to go faster than those who are in the right lane. and that trucks are relegated to the middle lane and the right lane, and that the left lane is for passing by cars. That's just, I want to make sure that everybody understands what the rules are that are in place. You certainly have the legal power to change them. But I
Thank
need
you,
to understand the
Thank you,
correct.
Director Mills. We have another question, Representative Wayne Perry.
Yeah, Peter, real quick, a couple things. Don't almost every state have these same rules on the truck travel? Maybe this is a better question for Tim Doyle, but it seems though, I know I've driven up and down the East Coast, and it seems though that almost every state, I believe, has that same rule. Even states with 4-lane roads, the trucks are kept in those 2 right lanes, you know, to pass and everything else. But also, it seems though we had a similar bill, geez, I want to say 8 or 10 years ago. And wasn't there a big question about when the lanes go from 3 to 2 or from 2 to 3? The average driver gets confused on what they're supposed to be doing or what they could be doing. I can't remember. It was quite a while ago, but I figured I just mentioned that too.
It may well have been, but I don't remember the bill you're talking about. We'd be happy to look back and see if we can find it. But there are other states that do restrict traffic in the left, that tell trucks not to be in the extreme left lane. I believe there are states that do allow it also, but it is a matter of, it does vary, I think, but there are lots of others. I think to answer your question, there are other states, and I think there are a number of them that do put up signs, as we have, saying no trucks in the extreme left lane.
But I think there was, wouldn't it be an issue too, on going from a 2-lane road to a 3-lane road? If there's, you know, when people say the center lane and they're in a 2-lane road, there really isn't a center lane, it's the left lane. But wouldn't this make some confusion possibly? And maybe that's a better question for Lieutenant Scott.
Yeah, at least with the 2-lane road, everything is very clear. Left lane is passing, right lane is travel. Boom, no difficulty. And that's true for all vehicles. So the 2-lane road is the simple case. When you build a 3rd lane, you're getting in, you then have to think about it and establish some policies, as we have done.
You all set, Representative Perry? We have another question, Director Mills, from Representative Williams.
Thank you, Mr. Chair. Director Mills, I have a simple question, and I could probably look up the answer, but since you're here, I'd like to ask you. Are buses and or large RVs also prohibited from the left lane in a 3-lane situation?
I don't think so, but you know what I've got to do? I want to get the wording that's on the sign. Because that's very simple and very direct. And let me get that for you and let you know. That's a very good question. I think it's trucks. I think it's freight carrying trucks. I don't think it's RVs. I think RVs are allowed to use that lane.
And buses also.
And I think buses are, but let me find that out for you. That's a good question.
Yeah, Director Mills, if you could, when you can respond to that, send it to our clerk, Darlene, so she can distribute it to other committee members.
We'll do that.
Thank you, sir. Are there other questions of Director Mills? I see none. Moving forward on LD 228, we have some more testimony from someone who wishes to oppose LD 228. Is Mr. Doyle available?
Good afternoon, Representative Martin, members of the committee. My name is Tim Doyle, and I'm the Vice President of the Maine Motor Transport Association. We represent over 1,500 member companies whose 32,000 employees make their living in the trucking industry. I think Senator Carney has adequately reflected my testimony, and Director Mills also made many of the points that I'm going to make. But as you know, current law requires operators driving on a limited access highway where the speed limit is 65 miles per hour or more to drive in the rightmost lane. The center lane and the leftmost lane may only be utilized for passing, after which traffic must return to the rightmost lane for travel. As it's been mentioned, however, truck traffic is prohibited from the leftmost lane and must travel only in the rightmost lane unless passing in the center lane. This bill seeks to authorize regular travel in the center lane in addition to the rightmost lane. The leftmost lane would only be used for passing, after which all vehicles would be required to return to the centermost or rightmost lane. Truck traffic, however, would still be prohibited from the leftmost lane. As Senator Carney quoted, I know that many of you think that's already the law. Even when you talk to colleagues at work or around the water cooler, people who travel the turnpike think that center lane is open for travel. Our opposition to this bill is primarily a safety concern. If the normal course of travel is legalized in the center lane, in addition to the rightmost lane, trucks will lose their ability to use the center lane for the passing of slower traffic. This could result in congestion in the more populated areas of southern Maine. It's important to note that truck traffic has only been prohibited from the leftmost lane of a 3-lane highway since 2004, when the turnpike was widened to 3 lanes. The Turnpike Authority at that point prohibited trucks by rule in order to fulfill an environmental requirement of the State Transportation Improvement Plan. And it was not primarily due to any safety concerns at that point. As has already been discussed a bit earlier, the committee, as you contemplate this bill, should be aware of a companion bill, which is LR 411, and that bill is sponsored by Representative Kinney. It's our understanding from talking with her that her bill would seek to allow trucks to travel in the leftmost lane when passing, thus harmonizing the use of the entire turnpike for all traffic. It's also our understanding that the Turnpike Authority is at least considering the allowance of trucks to use the leftmost lane when the widening is completed from mile 44 to 49. Because the speed limit in that area is 60 miles per hour, and there are some other safety features in that area. This could undoubtedly cause some confusion, as trucks would be prohibited on some parts of the turnpike from the left lane, but not others. It's our hope that the Turnpike Authority can revisit the issue that prohibited trucks from the leftmost lane on the turnpike, and that this committee will ultimately allow for trucks to safely utilize the leftmost lane for the entire turnpike when passing. We believe this would be safe, efficient, and fair. Traffic is safest when free-flowing and at the same relative speed and in the same direction of travel. Additional congestion caused by slower travel in the center lane without the ability for trucks to pass would lead to a disparate speed and congestion, which is often a contributing factor in crashes. For this reason, we respectfully ask that you vote ought not to pass on this bill. Thank you, and I'd be happy to answer questions.
Thank you, Tim, for your testimony. Questions from committee members? I see none. I guess you're off the hook, Mr. Doyle. Thank you. Darlene, that's all I have for folks who wish to testify in opposition.
We have, yep.
The chair will now entertain testimony from those who wish to speak neither for nor against LD 228. Is Lieutenant Scott available?
Yes, good afternoon, folks. Representative Martin and distinguished members of the Joint Standing Committee on Transportation. My name is Lieutenant Bruce Scott, and I am the commanding officer of the State Police Traffic Safety Unit. I'm here today to testify on behalf of the Department of Public Safety and the Maine State Police, neither for nor against LD 228. LD 228 seeks to change the current law regarding the normal flow of traffic on divided highways. I want to point out some concerns that the committee may want to consider as you deliberate on this bill. Current law under 29A 2052-6 requires motorists to operate in the right-hand lane and allows motorists to use the center and left lanes for overtaking. While there is often a need to use all the lanes of a multi-lane highway, at times vehicles operate in the center or left lanes in a manner that impedes the flow of traffic and creates a safety hazard. Traffic has been trained for years to keep to the right except for when overtaking, and as a result, the slower traffic keeps to the right, and this forces faster vehicles to pass on the left. Allowing motorists to travel or camp in the center lane may well force traffic to pass on both sides of the road. While it is lawful to pass on the right side of the road, it is not recommended due to the traffic ramp. The difference in speed between vehicles is what creates the most danger, and the unexpected slow traffic in these lanes is what creates sometimes the unintended hazards. We fear that the number of crashes may increase if the law was changed that eliminated the authority for law enforcement officers to stop vehicles from unnecessarily and unsafely traveling in the center lane or left lane. Another consideration is that tractor trailer units are statutorily prohibited from driving in the left lane. It is a rule on the main turnpike, as was already pointed out under Title 23, Section 1981A. So it does carry the weight of law as it's incorporated by statute. Therefore, the tractor trailers are not allowed to use that left lane. They're forced to use the center lanes for passing. If the center lanes are blocked with slower moving traffic, these trucks will likely pass on the right or illegally on the left, or be required to slow down rapidly and at times perhaps create a stall in traffic. The Maine State Police believes that this bill may be unnecessary as we're not aware of any problems with the current law. Traffic typically flows smoothly using all lanes as necessary for safe passage, and it is common practice within our agency to allow for operation on all lanes unless doing so creates an unsafe condition. For these reasons, we are neither for nor against LD 228. On behalf of the Department of Public Safety and Maine State Police, I thank you for your time and would be happy to answer any questions that you may have.
Thank you, Lieutenant, for your testimony. I see Representative Wayne Perry has a question. Representative Perry.
Yeah, good afternoon, Lieutenant Scott. Thank you for testifying. I kind of agree with you on not knowing if this was really necessary. Would this be something would be under the police discretion on if somebody's camping in that middle lane, impeding traffic, that person might get pulled over, but in the regular course of traffic, if somebody's driving in the middle lane, it's not really an issue if they're not impeding traffic?
Yeah, thanks for the question, Representative Perry. And that's a fair question. It certainly is discretionary. I looked up in the e-citation module, which is what we use to write tickets, to try to really get my arms around, is this a problem and how often are we enforcing the statute? And we've only enforced that particular statute 10 times on the main turnpike in the last year. And so I went through and I looked at some of the notes, and what I was finding in the notes from the officers involved were that either the vehicles were traveling at an extremely slow rate of speed of say 45 miles an hour and backing up traffic, but we had the exact opposite of that. One of them was doing 99 miles an hour in the center lane and was stopped and cited for that, but also cited for traveling in that center lane unnecessarily. So I guess the answer is it's discretionary, and typically what I'm hearing from the officers down there, as well as Lieutenant Baker, who's the commander of the main turnpike crew down there, they're telling me that they don't use it often, but they use it as necessary to make sure that traffic flows properly. And so when they see a problem, they address it.
Thank you very much. Yeah, I just think if that's allowed, it's going to be a real issue on tractor trailers passing. And it's almost going to force them to that third lane, which makes them break the law. Thank you.
You're welcome, sir.
Other questions from committee members? I see none. Folks, that's all we have for folks that desire to testify. And with that in mind, having received all testimony from those present today, I will now close the public hearing on LD 228. Thank you.
Thank you very much.
Darlene, do we know if Senator Farren is still on?
I don't see him.
All right. We're going to take LD 230 out of order.
Okay.
LD 230 is an act to allow low beam headlights on motorcycles to flash during daytime hours. Is the sponsor available?
He's coming. Hold on. There he is.
All right. Good afternoon.
Good afternoon. Thank you, Representative Martin. How are you?
Great, we're doing great.
All right.
I see Senator Diamond is here as well.
Thank you.
Oh, that's scary. Whoops, sorry. Well,
Ought not to pass.
yeah. Good afternoon, Senator Diamond, Representative Martin, and distinguished members of the Transportation Committee. My name is Dave Miramont, and I proudly represent all the people of Appleton, Camden, Creehaven, Cushing, Friendship, Hope Island, Matinicus, Muscle Ridge Islands, North Haven, Owl's Head, Rockland, Rockport, South Thomaston, St. George, Thomaston, Union, Vinyl Haven, and Warren, and the Maine Senate. I received a request from a constituent to allow motorcycle headlights to flash during daylight hours. They believe that this will enhance safety while riding, and for that reason, I introduced this bill. While current Maine statute does not require headlights to be illuminated during daylight hours, manufacturers of motorcycles do not allow for switching off the headlight at any time. It's been proven to increase visibility of motorcycles, and many states do require daytime running lights. I have direct experience with this type of situation. When I first began riding motorcycles on the road, there was no training or information presented that lights improved safety. I was 18 years old the first time a driver pulled out from a stop sign and directly into my path, leaving no time for me to stop. I jumped over the car as my bike was demolished on the side of it. This came just 1 year after my best friend had been killed in the same type of accident, and it sent me searching for answers to make riding more safe. I discovered that headlights turned on during all operations in any vehicle had that effect, and always use them to this day. The reason to add this to the statutes is to send clear permission to operators of motorcycles and law enforcement that it is a legal and desirable operation. It removes the guesswork and wasted traffic stops while trying to maximize safety by removing opinion from the equation. I've also discovered that some motorcycles are equipped with modulators that will sequence between high and low beams, and request that if you create this permission, you also amend the bill to allow that operation as well. Thanks for your consideration. I'll try to answer any questions.
Thank you, Senator, for your testimony. Are there any questions of the good senator? Seeing none, I guess you're off the hook, sir. The chair will now take testimony for those wishing to speak in favor of LD 230. Seeing none, chair will now take testimony from those wishing to testify in opposition to LD 230. Seeing none, the chair now recognizes Lieutenant Scott, who wishes to speak neither for nor against the bill. Representative Perkins, you had a question?
We can let Lieutenant Scott go, and then I'll go after him, sir.
All right, go ahead. Lieutenant Scott, you available?
Yes, good afternoon, folks. Just for clarification, we actually oppose this bill. I'm not sure if maybe I checked the wrong box, but the Maine State Police does oppose this bill.
Great, thank
So
you.
Senator Diamond, Representative Martin, distinguished members of the Joint Standing Committee on Transportation, my name is Lieutenant Bruce Scott. I'm the Troop Commander of the Traffic Safety Unit for the Maine State Police, and I'm here to testify on behalf of the Department of Public Safety and the Maine State Police in opposition to LD 230. This bill, if passed, would allow motorcyclists to use a flashing low beam headlight or headlights during daylight hours. We understand the goal of this bill is to increase visibility of motorcycles, thereby, in theory, increasing the overall traffic safety. Flashing headlights can be very distracting and perhaps cause more harm than good. Current law only allows flashing headlights on emergency vehicles, highway maintenance vehicles, and school buses. We would not want to trick motorists into thinking that an emergency vehicle was coming, nor would we want to desensitize them if the streets were flooded with flashing headlights. Motorists are forced to make a split-second decision on how to operate or maneuver their vehicles with regard to a multitude of stimuli within the environment. Lights on vehicles convey a message depending on their size, shape, color, location, and functionality. A vehicle displaying flashing headlights currently commands action on part of the other motorists that includes stopping, slowing, pulling over, or passing by with extreme caution. And I'm sure that's not the intent of this bill, but rather a potential outcome.
Thank you,
A better solution to increase visibility during daylight hours on motorcycles that doesn't compromise safety is a modulating headlight which is already authorized by law, as Senator Marymount had alluded to. This type of headlight is safer. It meets the Federal Motor Vehicle Safety Standards. It's permitted in all 50 states, and it serves the same purpose. The difference between the two is that a modulating headlight will cycle from a dim light that as low as 17% power to that of a brighter light as high as 70% at its top cycle. While there is already a viable option for motorcyclists to be more visible, we would ask the committee to carefully evaluate the potential benefit to that of the risks when finalizing the decision on how to proceed with this bill. For these reasons, we urge you ought not to pass on LD 230. On behalf of the Department of Public Safety, the Maine State Police, I thank you for your time, and I'd be happy to answer any questions that you may have.
Thank you, Lieutenant, for your testimony. Representative Perkins.
Next time I want to go in front of him, he speaks too well. So good job, Lieutenant Scott. I teach motorcycles, train motorcycles, taught over 700 people last year how to ride motorcycles. I don't believe this would do any good. And it goes back to the same thing that Lieutenant Scott said, by a flashing headlight, someone's going to think there's a police officer behind it. Modulated headlights are great. They do a good job. So I'm really worried about doing something that would distract the people, because if you see something flash, like we argued about putting wigwags on school buses a year ago, and same thing goes back. I mean, that's why they're supposed to get people's attention. I prefer not to take and do that with a motorcycle. And then what do you do with all the people with the modulated headlights already? But thank you for your time, Mr. Chair.
Representative Perry.
Yes, Lieutenant Scott, you stated that the modulating headlights are already legal to do. So
yes,
we don't need a new law to say that it's legal to do.
Well, perhaps Senator Marymount was talking about specific examples of maybe police officers that didn't know the current law. That's kind of what it sounded like he was saying, because, yeah, it currently is authorized by statute. Federal law actually has to trump state law as it comes to the manufacturing of all motor vehicles. And so that Federal Motor Vehicle Safety Standard under 571-108 has been met, and no state can prohibit the use of a modulating headlight on a motorcycle.
Okay, thank you very much.
You're welcome.
Other questions? I see none. Having heard all the testimony on LD 230, the chair will now close the public hearing in regards to LD 230. We will now move forward with LD 186. LD 186, an act to allow signs in the public right of way to be removed by the landowner. Is the sponsor available?
She is now.
Just got to make sure I get back off of mute. Good afternoon, Senator Diamond, Representative Martin, and honorable members of the Transportation Committee. I am Representative Mary Ann Kinney, and I represent House District 99, which includes the towns of Brooks, Burnham, Freedom, Jackson, Knox, my hometown where cows outnumber people, Monroe, Thorndike, Troy, and Unity. I am here to present LD 186, an act to allow signs in a public right-of-way to be removed by the landowner. In 2015, Title 23 MRSA Section 1917-A was repealed and replaced by Section 1917-B. In doing this, the section allowing landowners to remove, in particular, political signs without penalty was repealed. All this bill seeks to do is to reinstate that a landowner may remove signs that are placed essentially on their front lawns without facing the $250 fine. As I was preparing for today's public hearing, rereading the language in this bill more thoroughly, it was my first bill that I reviewed under our all digital system. I realized it allows the landowner to deface political signs without penalty, and this should not be allowed. I would like to offer a friendly amendment that would go back to my memory of the former language, which I'm sure your analysts will be able to get their fingers on easier than I can. I am forever grateful for the work that our analysts do to keep us all going. The amendment should have some language to require the landowner to make an attempt to notify the sign owner, since the 2015 language required that the sign owner have contact information pursuant to Title 23 MRSA, Section 1913A, subsection 1, letter L. Many of us have reused our signs from one campaign to the next, and this is a significant cost to candidates. Plus, it'll help the environment by reusing the signs in subsequent election cycles. As I mentioned earlier, there should be language that even a landowner cannot deface a temporary sign including but not limited to the political signs. And I'd be happy to answer any questions you may have at this time. Thank you.
Thank you, Representative Kinney. Questions from committee members? Seeing none, thank you. The chair will now entertain testimony from those wishing to speak for LD. What was the LD number here?
186.
186. Thank you, Darlene. Seeing none. Testimony will now be heard from those who are in opposition to LD 186. Seeing none. I see that we have an individual who would like to speak neither for nor against 186.
Good afternoon.
Good afternoon, Ms. Russo. How are you?
I'm very well. How are you?
Great.
Senator Diamond, Representative Martin, members of the Transportation Committee. My name is Mega Russo. I am the manager of Legislative and Constituent Services at the Maine Department of Transportation. Maine DOT is neither for nor against LD 186. Maine DOT has long accommodated the placement of signs in the public right-of-way in accordance with the Maine Traveler Information Services Act as defined in Title 23, 1913A. As many on this committee are aware, the U.S. Supreme Court's 2015 ruling, Reed versus Town of Gilbert, prohibits the regulation of temporary signs based on content. The Reed decision specifies that temporary signs can only be regulated by time, place, and manner. During the 127th legislature, this committee heard LD 1592, an act to amend the Maine Traveler Information Services laws, which was in direct response to the Reed decision. LD 1592 changed Maine's temporary sign laws to conform with the Supreme Court ruling. LD 186 seeks to amend the section of statute that pertains to the unlawful removal of temporary signs. The bill seeks to allow the property owner adjacent to the right-of-way to remove a temporary sign that has been placed legally in the right-of-way in front of that owner's property. Maine DOT understands that signs being placed in front of a person's property can cause frustration, especially if the property owner does not agree with the message on the sign. I am keenly aware of these frustrations because I am the person at Maine DOT who fields many of the questions and complaints from both sign owners and the members of the public. While there may be a desire to further change Maine's temporary sign laws, any further changes will need to remain in conformity with the Reed decision, or Maine DOT will be unable to continue enforcing Maine's temporary sign laws. Aside from the inability of Maine DOT to regulate the measures proposed in this bill, the passage of LD 186 could have negative implications on the state. An argument could be made that a property owner being allowed to choose which temporary signs are legally placed in the public right-of-way could be considered regulation based on content, as well as a potential infringement on someone's First Amendment rights. As the agency responsible for implementing sign regulations, we appreciate the committee's guidance on how to continue effectively enforcing the law while remaining in compliance with this Supreme Court decision. Without compliance, the department will be unable to enforce Maine's temporary sign laws without being in jeopardy of attracting litigation. We would suggest that this committee seek input from the Office of the Maine Attorney General if it is inclined to make changes to the temporary sign laws. Thank you for your time, and I'd be happy to try to address any questions the committee might have.
Thank you for your testimony, Ms. Russo. Questions of committee members? Senator Diamond.
Thank you, Chair. I appreciate the recognition. Could you, Ms. Russo, could you provide the committee with your testimony? I don't have it unless you already have. But I seem to have.
I sent it through the online portal, but sure, I can email it to everyone.
Thank you very much. Thank you, Ms. Chair.
Representative Williams.
Yes, thank you, Mr. Chair. I just want to state that as someone who's done decades of First Amendment law, I completely concur with Ms. Russo's testimony, particularly with regard to the U.S. Supreme Court case, the Reed case. I just wanted to throw that out there. Thank you.
Thank you, Representative Bruce White.
Hi, yes, thank you. I was just wanted clarification on either from Megan or Representative Kenny when Representative Kenny referred to it's just a change to just to put it back the way it was. Was that could you elaborate on that, Megan?
So prior to my time at DOT, while I've been at DOT, it's never been in statute that the property owner can, an adjacent property owner can remove a temporary sign from the public right of way that's there legally. Maine DOT, again, my time at DOT has always been the enforcer of Maine's temporary sign laws. So we're talking the public right of way that typically I tell candidates or anyone looking to put up a sign, generally is 33 feet back from the center line of the roadway.
Okay, so maybe, Mr. Chair, is that all right if Representative Kenny could explain that?
If she's still available, that would be great. Representative Kenny?
Sure, I know I'm not really supposed to, but this whole
No, go
format
ahead.
is so different.
Go ahead.
I'm wondering, maybe I have a different definition of these right of ways, because I think of like the corner field that is owned by a farmer that they own through that public right of way, which is a DOT right of way, not necessarily a public right of way. So maybe I'm thinking of a different, maybe the language is not exact for what I'm trying to say. Essentially, we've had issues in my district, and this is part of why I've brought it forward, because signs were disappearing. Plus, when a person that owns property, that right of way is a DOT right of way on the personal property. So I guess I'm confused as to what a public right of way is versus the right of way that DOT is allowed to do to make sure the roadway is still clear to be able to maneuver traffic along the road.
Thank you, Representative Kenny. Representative White, you all set?
Yes, thank you.
All right. Representative O'Connell, I'm sorry, Kevin.
That's all right. You just missed one letter. I've run several elections for myself, and I'm just having a hard time grasping this, because anytime I put a sign up in front of a business or a house, I always check with that person to make sure it's okay. I'm a little confused as to why somebody would think it would be okay for it to do that. If anybody can explain that to me, maybe I'm being naive, I'm not sure. If anybody can offer clarification, I'd appreciate it.
Representative, I guess we can further discuss that during the work session, or maybe reach out to the department. Is that okay?
Okay, that's fine. Thank you.
Representative Perkins.
Just a quick clarification. Title 17A 806 states it's criminal mischief if you go start moving signs and taking signs off, or destroying personal property. So that's part of this. The other part is that I just, for chuckles, I guess maybe I could start sending the DOT some of my tax bill every year, because I get charged right up to the roadway, Megan. Just chuckling.
That wasn't a question, right? No comment.
All right. So that wasn't a question, was it? All right. Are there others who wish to ask questions in regards to this particular LD? I see a couple of hands up, but I think Representative Perkins and O'Connell, you're all set? Or did you have another question, Kevin? All right, great. I believe that's all the folks.
I have a real quick one, Representative.
Go ahead, Representative Perry.
Yeah, Megan, if this becomes a real issue, our only recourse is not allowing them on the right of way, correct?
I mean, that's one thing that the committee could discuss. And actually, I think you have a bill coming before you. Your next temporary sign bill is to ban all temporary signs.
I believe it's been common courtesy, but common courtesy lately has gone out the window in some
So
instances.
you mean in terms of asking the adjacent property owner to put
Well,
the sign in the right of way, or?
I hate the word adjacent because it's in front of somebody's house.
Correct, yes.
So I wish we wouldn't use adjacent. I wish we'd use in front of somebody's house.
So
And that's
typically-
the issue.
Not everyone, and this kind of touches upon Representative O'Connell's question, not everyone will ask the property owner that abuts up to the right of way if they can place a sign in front of that property. I think some candidates do, or some temporary sign owners do, but that is not always the case. And I do get a lot of complaints every year, every election cycle. And typically what I tell the person complaining is that if they reach out to the sign owner, which is oftentimes a candidate, that candidate is going to be more than willing to move that sign, come and collect it. And I think they would prefer to do that than have the property owner next to the right of way go out and remove it themselves. So
I mean, I've always looked at it that like corners are kind of free game of corners of streets and stuff like that. But I put one on a corner one time and the property owner that owned the corner said no, and I went and picked it up, but just as a common courtesy, even though I knew I could legally do it, I didn't. But I think the big frustration is when they get put right directly in front of somebody's house, you're assuming that property owner is endorsing that person or that company or that business or whatever, when they might not be. That gets into, I would think, and I know the sign owner has First Amendment rights, but I would think the property owner would also have them. Thank you.
Thank you. Representative O'Connell, does that help answer your question?
Yes, it does. Thank you.
Okay, great. Thank you. I believe that's all the folks who have registered to testify. And with that in mind, the chair will now close the public hearing on this particular LD. Thank you, folks. Senator Diamond, are you, Senator Diamond is on, correct?
Yes.
Yeah, we, because Senator Farren had to leave and come back a little earlier, we haven't done the LD 154 yet.
Okay.
And we still have to do LD 236. Would you like the gavel on 236?
You're doing a great job. It's up to you. You're doing fine.
Great. With that in mind, thank you, Senator. With that in mind, we will now take up LD 236, which is an act to amend the definition of reportable accidents. And is the sponsor available?
She is here. Hold on
Representative
just a second.
Hepler.
Hold on.
The
She's
floor
coming.
is yours.
Oh, there she is.
Okay, sorry. I'm still getting used to that whole swirly thing where you can't see anything.
I know, it's crazy, isn't it?
Oh, yeah. So it's really nice to see different faces here, especially in Zoom world. So, and I want to say hello to Representative Perry here. We last met in former Representative Lance Harvell's social studies class. So it's nice to see you. Senator Diamond, Representative Martin, I'm afraid my first testimony came through as Representative Chipman as being chair. I apologize for that. And esteemed colleagues on Transportation Committee, I'm Allison Hepler, and I proudly represent the towns of Arousek, Dresden, Georgetown, Phippsburg, Woolwich, and part of Richmond. And I'm here today to present LD 236, an act to amend the definition of reportable accident. Currently, unless an accident results in, quote, serious bodily injury or death of any person, Title 29A, Chapter 19, Subchapter 3, only requires that the accident be reported by the quickest means to the appropriate law enforcement office. This bill would amend reportable accident to include hitting a domestic animal. The idea for this bill came from the personal experience of a constituent whose dog was seriously injured by a vehicle that did not stop. I was actually surprised that hitting an animal of any kind is currently not required of drivers. So I see this bill as not creating another level of bureaucracy and record keeping for law enforcement and/or insurance companies, but as a way to hold drivers accountable. It's also a humane and caring method of ensuring that pet owners, A, learn of the injury, especially if this occurs at some distance, and B, are possibly able to recoup some of the costs of injuries to their domestic animals. Frankly, my hope would be that the passage of this bill reminds drivers to do their best to stop and look for the owner of an animal that they've hit. This is in the best interest of the injured animal as well as the driver and the owner. There may well be unintended consequences of adding this category of reportable accident, but I leave it in the fine hands of this wonderful committee to balance any competing interests. I will also mention that other states have similar legislation, although I haven't done extensive research on this. My purpose here is to create some peace of mind for pet owners who do not intend to put drivers at risk by having their pets at large, for drivers who don't intend to harm animals, and for pets. So thanks for your time, and I'm happy to take any questions.
Thank you, Representative. Questions of committee members? Seeing none, I guess you're off the hook.
Thank you.
And I see we don't have any co-sponsors who have registered to testify. The chair will now take a testimony for those who are proponents, those who are in favor of LD 236. I believe on my list we have former Representative Kilkelly. Is she available, Darlene?
Yes, she is. She's right there on the
All
screen.
right.
Marge, you need to unmute.
Oh, I thought you had to do that.
Nope, you do it.
I live on Zoom. Who would notice, right? Senator Diamond, Representative Martin, members of the Committee of Transportation. My name is Marge Kilkelly. My husband, Joe Murray, and I live in Dresden at Dragonfly Cove Farm, where we raise goats, poultry, and pigs for local markets. We are helped in that work by Percy, who is a 19-month-old Briard herding dog, and a glare of barn cats. I'm pleased to be here today to testify in support of LD 236, an act to amend the definition of reportable accident, and to thank Representative Hepler for listening to our concerns and submitting this legislation. You have I believe you have my testimony in front of you. On August 7th at about 5 in the afternoon, a group of neighbors were working on our goat fences, and our dog Percy and their dog Bo decided to walk to the neighbor's house to visit. Clearly not something he should do. The neighbor kindly gathered both dogs, and as he was walking them back to our property, a car came around the corner, swerving from the dirt into the middle of the road, back into the dirt, back into the middle of the road, completely out of control. And at one point, when it was in the dirt, it hit Percy. Our neighbor was almost hit as well. Bo was not. The car sped off, didn't stop at all, even though a person was nearly run over and a dog certainly was run over. Then a bicyclist stopped just after this accident occurred. It turns out that he had almost been hit also by that same vehicle on Indian Road just before it turned south on River Road. This section of the road is usually not terribly active. We live out in the country. But that day there were neighbors jogging, there was a bicyclist, our neighbor clearly was walking the dogs back, and this person still felt comfortable just driving off, speeding off, as a matter of fact. We took Percy to the vet, and he had a couple of surgeries and a number of other things that needed to be done, and started looking at what can be done when someone does just take off. Under current law, property damage of more than $1,000 must be reported. Percy easily meets that criteria, and his medical care alone was more than $5,000 so far. But this isn't about the money. It's about common decency and animal welfare. The person, still unknown, but we are still looking, who hit Percy has committed a crime by leaving the scene of a reportable accident with damages over $1,000. Well, one of my concerns was, what about the beloved adopted dog who doesn't have that level of monetary value? That animal, any animal, scared and hurt, could run off into the woods and never be found. That's not okay. It's sad that legislation is needed to get folks to do the right thing, but we all know that's the case. And no matter what legislation is passed, there are always going to be those who ignore it, and penalties need to be there for that. My husband and I take full responsibility for Percy leaving our property. We realize that if he were to be in the road and cause an accident, we would be liable. In this case, he was under the control of a person and on the side of the road. The car was in the wrong place, and one must wonder why the driver felt the need to speed away. I hope someday we'll find out. I've done some research, and there are several other states that in fact do have penalties for or requirements to report domestic animal accidents. Some even use the animal welfare statute by saying that it's cruelty to animals if you have run into a dog or a cat and you just drive off and don't make any attempt to address the injuries, that in fact is animal cruelty. Thank you for your consideration of this legislation. I am pleased to attend the work session and provide any additional information. I will be scouting some more statutes and see what else I can find. And for Senator Diamond, as this bill was coming along, I had this memory thing of our dear friend, Representative Mulholland, many years ago, who would say, but this is just a little bill, just a little bill.
Okay.
Thank you so much.
Thank you, Marge, for your testimony. It's great seeing you again.
Oh, thanks.
Questions of committee members? Seeing none, I guess we're all set. The chair will now take testimony from those who would like to speak neither for nor against this particular LD.
We got Dana Duran, who's
Who
in
wishes-
opposition.
Okay, I don't.
First.
Okay. Dana, are you available?
I am, yes.
Go ahead, sir.
Thank you. Good afternoon, Senator Diamond, Representative Martin, and distinguished members of the Committee on Transportation. My name is Dana Duran, and I'm the Executive Director of a trade association here in Maine called the Professional Logging Contractors of Maine. Our organization represents loggers and truckers throughout the state, and all the folks who work for them. Logging is a $620 million component of the Maine's forest economy, which is worth over $8.5 billion. Logging and trucking is responsible for about 3,900 jobs in the Maine economy and also produces about 5,400 additional jobs. I come before you today to testify in opposition to LD 236. And while I certainly understand the good intentions of Representative Hepler, as well as hearing Ms. Kilkelly's story and knowing her for a long, long time, I certainly understand where they're coming from. That said, we can't support the inclusion of domestic animals in the current statute because of unintended consequences upon our industry. I did provide my written testimony. I'm going to summarize that for you and kind of cut to the chase, but I think most folks here know what has happened to our industry over the last year since the pandemic started, and certainly what's happened since the two digesters at the J Mill exploded. Our folks have seen anywhere between a 30 and 50% reduction in market share, and that's had an enormous impact upon their livelihoods, their ability to employ people in rural Maine, and I'm sure you all understand that. That being said, I do want to kind of cut to the chase of what this bill could do to our industry at such a tenuous time, not necessarily just now, but for the future. So I think, from our perspective, it certainly could have tangential consequences. And I'd like to raise two issues, knowing that they only scratch the surface with the impacts of this bill. First, what is the definition of a domestic animal? This can be quite subjective and may be different in various parts of the states, and even more so in the eye than from the eye of the beholder, so to speak. In our industry, would the commercial timber hauler need to report the death or injury of any animal strike if it is deemed to be domestic? would they be held liable if they didn't notice that there was an animal strike that perhaps occurred outside of their sight line? And I'll just use the example of a 6-axle truck and trailer combination. If they are going down any roadway in Maine and they don't see that domestic animal in their sight line and it occurs in those 3 rear axles, what is going to be their liability inevitably? And it certainly was nothing they intended to have happen, nor did they even notice that it happened. Second, what will be the impact from the perspective of commercial vehicle investigations? In the current statute 29A MRSA section 2251, if any accident results in a bodily injury or death, it triggers a commercial vehicle investigation if the vehicle weighs in excess of 10,000 pounds. Thus, if domestic animal is included in the statute and an animal strike causes a death to the animal as it reads now, it will trigger a commercial vehicle investigation. This one small change could trigger devastating economic losses to any company, to the supply chain, and it could also lead to increased pressure on an already strained commercial vehicle inspection group in the state police. And lastly, I mentioned it previously in my testimony, are the insurance impacts. I can tell you right now that, every one of our companies has a commercial liability, whether it's pickup trucks that they give to their employees or to their commercial vehicles that carry wood, round wood, or chips. And I can tell you every insurance company in the state will increase automatically the premiums that are paid as a result of this small change. So for those reasons, we urge the committee to vote ought not to pass, and I would be happy to answer any questions.
Thank you, sir, for your testimony. Questions from committee members? Senator Diamond.
Thank you. Thank you, Mr. Chair. Just quickly, Mr. Duran, do you see any possibility of a compromise here where we could consider any portion of this bill that might actually make a lot of sense, and at the same time, the ideas or the issues you pointed out, especially the last 3 axles, the blind spots and all that, do you see any area where there might be some kind of compromise?
Sure, that's a very valid question, Senator. I'd be open to talking about any type of compromise. I'd have to see it first and understand what it is. I think obviously from our perspective, the commercial vehicle component is enormous and the insurance components are enormous, and anything that adds burden is going to increase cost. So I would be cautious, but I certainly would entertain a conversation. Absolutely.
Thank you.
Thank you, Senator. And Mr. Duran, I gather you'd be available to discuss this further during a work session?
I would be happy to, Representative Martin.
Great, thank you, sir. Representative Perry.
Yeah, just real quick, Dana. Wouldn't it also be a problem knowing if it's a domestic animal that you might hit in the middle of the night at 2 a.m? Yes, if you're in front of somebody's house with the lights on, you would know that it was probably an animal in the neighborhood. But on a more rural area, would you even know that it was a domestic animal that you hit? So, is this going to be a big issue with pulling commercial vehicles or even a private vehicle off, going through the woods looking for an animal that might or might not be a domestic animal?
You raise valid points. I think anyone in our industry is sensitive to the situation with a domestic animal. No one wants to strike another animal. They know what their obligations are, but you raise, certainly valid issues. I mean, our log trucks and chip trucks are all over the state. They're on private dirt roads. They're on public right of ways. They're everywhere. And so, and it's at all points of night. You pointed out, 2 a.m. A lot of our folks, especially this time of year, are leaving home around midnight because they're trying to take advantage of winter conditions. So certainly seeing things in the dark is very challenging to begin with. And then to know exactly what has happened and then try to report that, it just causes complete disruption to the entire supply chain. And it adds a lot of cost. And it's certainly nothing that we want to have happen. And we want to take responsibility for actions that were certainly unintended. But you can also imagine what the ramifications are from a cost basis.
Thank you. Other questions? Seeing none. Having heard all the testimony in regards to this LD, the chair will now close the public hearing on LD
You
236.
didn't get Lieutenant Scott, did you?
Say what?
Lieutenant Scott.
Lieutenant Scott, I don't have him on my list, but I guess Lieutenant Scott, my apologies.
Thank you, Mr. Chair. Senator Diamond, Representative Martin, and distinguished members of the Joint Standing Committee on Transportation. My name is still Lieutenant Bruce Scott, and I'm the commanding officer of the Maine State Police Traffic Safety Unit. I'm here today to testify on behalf of the Department of Public Safety and the Maine State Police in opposition to LD 236. First, I'd like to say that we are very sensitive to the concerns that were raised. We understand why Representative Hippler had a desire to make this change. But this bill would add domestic animal to the reportable accident definition, thereby requiring a full investigation and reporting requirements if a domestic animal was injured in a crash. Current law already requires an investigation and a report if there is any injury to a person or damage of property of $1,000 or more. A pet is considered property and thereby already requiring a report if the pet is valued at $1,000 or more. If this bill was passed as written, a person who hits a cat, a ferret, a gerbil, or etc. would be required to stop and report that crash. If the operator drove away from the scene, they would be committing a crime. The bill doesn't require that the operator knowingly hit a domestic animal, only that they did. Meaning that if you thought you hit a raccoon or a fox or a skunk or any other animal, you fill in the blank, but you actually hit a cat or a different domestic type of animal, you could be summoned and convicted for leaving the scene of an accident. Also, if this bill passes, a domestic animal that was riding in the vehicle with you gets injured, the same would follow. Say that animal jumps out of the window while you're driving and gets severely injured. Any injury at all would meet the definition, so just pain. You would be required to immediately stop your vehicle and report this incident. In the scenario, even if your animal was severely injured and had to be, say, transported for an immediate medical attention, you would not be allowed to leave the scene by the statute. You'd have to stay and wait for law enforcement to respond to investigate. Additionally, domestic animal is not defined in Title 29A, so a definition should be added if you are inclined to support this bill. Our final thoughts on this bill are unnecessarily creating an accident on a motorist driving record will likely cause their insurance rates to increase. There will also be times when police officers will get called out to investigate these new class of crashes that could create a fiscal note that's not yet determined. For these reasons, we urge you to vote ought not to pass on LD 236. We're glad to answer any questions that you may have. And I would just add that in the situation that was given where Percy was injured, the dog that was injured in this case, I agree with the owner that that would have been a crime. Current statute would address that, not just because of the value of the dog, but because of the operation of the motor vehicle. It's clearly driving to endanger. It's a Class E crime. The subject can be arrested, but unfortunately, it sounds like in this case, there's no evidence to know who that person was. Changing this particular statute to require us to do the investigation wouldn't have changed anything in this particular case. We already have the teeth that are necessary to go after dangerous operators. That's all I have. Thank you.
Thank you, Lieutenant. Chair apologizes. Our clerk does send us a panel list, but I think my printer's running out of ink here. So
No problem, sir. Thank you.
Zooming is quite a feature.
It is.
I believe that's all we have for testimony. With that in mind, a public hearing on LD 236, unless we have questions from committee members, and I see none, is now closed. Thank you. We will now move forward with, last but not least, LD 154. LD 154 is a resolve to rename Bridge 2267 in the town of Emden and the town of Solon to the Joseph and Emma Stevens Bridge. And I believe our sponsor is available.
He's coming on, or he should be coming on in just a second.
Darlene, do we know if Senator Farren is back?
He is not back yet.
Okay.
I'm here.
There he is.
Oh, here we go. Go ahead, Representative.
Good afternoon, Senator Diamond, Representative Martin, distinguished members of the Transportation Committee. My name is Jack Ducharme, Representative Jack Ducharme. I represent Maine House District 111, which is Norwalk, Solon, and Madison. I'm here to present LD 154, a resolution to name Bridge 2267 in the town of Emden and the town of Solon, the Jotham and Emma Stevens Bridge. I was approached by Rodney Hatch of Emden on behalf of Clayton Sonny Stevens Jr., now 85 years old, asking if there was a way to honor his ancestors by naming this newly reconstructed bridge. The naming of the bridge has the support of the select boards on both sides of the Kennebec, as well as the support of the Solon Historical Society and local historians on the Emden side of the river. On the western shore of the Kennebec River in Emden was a place that became known as Thompson's Landing. Around 1828, a ferry service across the river was started to transport people and goods to Solon. Historical records show that Jotham Jote Stevens lived at the ferry site as early as 1887 and was the last ferry tender when the first bridge was built between 1910 and 1911. The ferry tender was on duty night and day, sometimes being called from his sleep to ferry people and teams across. The rates for the ferry were 3 cents per single team and 10 cents per double team at the time the ferry stopped operating. The boat itself was large enough to carry 6 single teams or 4 double teams if the rigs weren't too long. The ferry ran by the power furnished by the current of the river. There were 2 poles, one on either shore with a cable between them. The current of the river pushed the back end of the ferry downstream and across the river at the same time. If the current was slow enough, it was sometimes necessary to pole the boat across the river. The ferry could only be used when the river was clear of ice. During the winter, people crossed the river on the ice when it was safe. The Stevens family has had a long and storied history in the Emden-Solon area. Genealogical records show that the family has lived in the area from the early 1800s. The family had been known as one of the oldest families in the area. No other family is more permanently represented in the Emden historical records. They held many offices, including selectman as early as 1817, constable, tax collector, town agent, moderator at town meetings, all through the mid to late 19th century. Jotham's uncle, David II, was postmaster and a much favored moderator and presided over town meetings in the 1860s and 70s. The Stevens house was the ferry tender's home and was commonly referred to as the Ferry House. This house was later owned by Clayton Stevens Sr. and Alice Stevens, Clayton Sonny Stevens Jr.'s parents. Jotham Stevens was Sonny Stevens' great-grandfather. Sonny Stevens is now 85 years old, as I said before. I thank you for your time and support and consideration of this resolution at this time. Thank you.
Thank you, Representative. Great job. Questions from committee members? Seeing none, I believe we have 2 co-sponsors who wish to testify in support of LD 154. I noticed that Senator Farren was one of the co-sponsors, but I'm not sure he's back.
He's not.
Who's the other one, Darrell?
Representative Zager? Or
Is-
Zager?
I see you're here. Go ahead, sir.
Thank you very much, Mr. Chair. Senator Diamond, Representative Martin, other honorable members of the Transportation Committee. I'm Sam Zager. I represent the good people of District 41 here in Portland. So pleased to join Representative Ducharme and Senator Farren in co-sponsoring this bipartisan bill. And I just want to take 1 minute, literally 1 minute of your time today to make a few comments. I've enjoyed learning about the town and times of Jotham and Emma Stevens, which Representative Ducharme briefly shared with us. And also the ways that their ferry service served the needs of the region. Thanks to historians of the Emden Historical Society and the Maine Historical Society, I in researching this, learned about how Jotham and Emma Stevens worked very hard and very honorably for many years, both in private service and also public service. The family also has a Portland connection. So the story of this family and this bridge is symbolic, I think, of how Maine itself is interconnected. All Mainers, rural or urban, longstanding on these lands, or newly arrived, thriving or struggling, born of any tradition, originally speaking any language, and having many beliefs and faiths, we all have a responsibility and an opportunity to work together to brighten our collective future. Thank you very much for your time, and I ask you to please vote for this bill. Thank you.
Thank you, sir, for your testimony. Questions of committee members? Seeing none. I note that Senator Farren is not back, but for the record, he is a co-sponsor and in favor of this LD. Are there those who wish to speak in opposition to LD 154? Seeing none. Those wishing to speak neither for nor against LD 154.
Good afternoon again.
Ms. Russo, welcome.
Thank you. Senator Diamond, Representative Martin, members of the Joint Standing Committee on Transportation. I again am Megan Russo, Legislative Liaison for the Maine Department of Transportation. Maine DOT is neither for nor against LD 154 and normally does not testify on bills that name roads and bridges, but because this is the first such bill in this legislature, we hope to give that an overview of past practice regarding such bills will be helpful. Maine DOT considers the naming of bridges, roadways, and other state transportation infrastructure to be within the purview of the legislature. Simply put, we build them and you name them. Accordingly, we generally do not take positions on so-called naming bills. However, we usually submit written testimony regarding whether the particular infrastructure under consideration has been named before, and if so, what those names are. In this case, we are not aware of any previous legislatively sanctioned names for this bridge. We also note that the committee historically has asked sponsors of naming bills to produce written evidence of support for the proposed name from the municipality or municipalities in which the infrastructure is located. This avoids some local issues that have prompted renaming bills in the past. We hope this information is helpful. In the future, we will simply submit written testimony on bills that seek to name roads and bridges. Thank you for your time. I'd be happy to answer any questions you might have.
Thank you for your testimony, Ms. Russo. Any questions in regards to LD 154? Seeing none. I believe that's all the testimony in regards to this particular LD. And with that in mind, the public hearing on LD 154 is now closed. Senator Diamond.
Thank you, Mr. Chair. Mr. Chair, I would move that, knowing that we have the appropriate documentation, we move into work session.
Motion has been made to move into work session by Senator Diamond. Do we have a second?
Second.
Great. All those in favor of the pending motion, just kindly raise your hand. No opposition. I believe it's unanimous. Senator Diamond.
Mr. Chairman, I believe that, as I said, I'd like to have it confirmed on, certainly in a formal way, but I believe we do have a letter from the select people there in the town, and there, as Ms. Russo said.
Senator Diamond, not to interrupt, are we required to take an actual vote when we do that? Because we're on Zoom.
We are required to take a vote.
You're correct, and the chair stands corrected. Darlene, would you call the roll on the pending motion?
Sure. Representative Perry?
Yes.
Representative Williams?
Yes.
Senator Chipman? Nope, he disappeared. Senator Diamond?
Yes.
Representative Martin, Danny Martin?
Yes.
Representative Perkins? No, he's gone. Representative Bryant?
Yes.
Representative Bruce White?
Yes.
Representative O'Connell?
Yes.
And Representative Seabra?
Yes.
Okay.
And clearly, Darlene, we have an affirmative vote. Could you
Yes.
mention the numbers?
Yep, 8 in the affirmative and then 5 absent.
Great, thank you. Senator Diamond.
Thank you, Mr. Chair. So as I was saying, I think we have the documentation. I'd like to have that confirmed, of course. And we have which includes the letter from the select people. And we've had, as DOT has reminded us, Ms. Russo, that this is a process which is clearly in the purview of our committee and then the legislature as a whole. So I would, having known that and get us to the point of discussion, I would move ought to pass.
Motion,
Mr. Chairman, I'm second that.
motion has been made on ought to pass on LD 154, duly made by Senator Diamond, and I believe seconded by Representative Seabra. Before we take a vote, any questions or discussion in regards to this? I see our analyst has his hand written. Sam, did you have a comment?
Yes, thank you, Representative Martin. I just wanted to confirm for the committee that we have received letters from the two towns that would be touched by this, and that's the town of Solon and town of Edmonton. And so we have received both letters in support. And also, we've received a preliminary fiscal impact statement for this bill that indicates that no fiscal note is required. So if you were to vote ought to pass on this, it would not require us to meet again to review a fiscal note.
Thank you. Motion has been duly made and seconded. Further discussion to LD 154. Representative Seabrook, you have a question.
Thank you, Mr. Chairman. I'd just like to make one quick comment. In now my 6 terms on this committee, we have never had a bridge naming bill that hasn't passed the committee, that's had its paperwork done correctly, gone through the select boards of the towns involved. And I'm just hoping that at some point in the very near future, this committee could sit down and discuss an opportunity to maybe make the process streamlined, save some taxpayer money, and let the department do its job. And I mean, when the paperwork's right, we pass these things. So I would like to see us talk about maybe streamlining this process and also educating legislators prior to the first session who are new, who do this, so they don't have to keep going back to their select boards and starting the process over again. Just a comment there.
Thank you, Representative. Representative Perry.
Yes, just real quick. I don't know if Megan's still there or not, but we've got all the right stuff. But should we pass this? Ought to pass as amended, because sometimes we have to tweak a word. It seems though that always ends up happening.
Representative, we don't have an amendment to vote on. No amendment to this bill has been presented.
No, but what happens is, do we have all the right numbers, because I've seen this happen, and most of the time we pass it as amended, and to fix any, and it goes to the analyst to make sure that that's all the T's are crossed and all that. That's all I was bringing up. Somebody that's been on the committee for this, my 5th term, we usually do that. So I was just.
I saw nothing wrong with the bill language, if that's what you're asking.
Okay.
Anyway, just a clarification from the chair. I understand the good representative's point, but there's no amendment in order for us to move forward with. Senator Diamond, did you have a question?
Mr. Chairman, I was just going to say that I know that our committee on these bills, these particular naming bills, we've done a number of things to make it go faster, and I appreciate Representative Seabra's comment too. But it seems that we could do something about that before we leave this year. But if something comes up, as Representative Perry said, we can always bring the bill back in, reconsider it, and then take care of that issue.
Yeah, it's a great point. Thank you. Additional comments, questions, or observations in regards to LD 154? A motion has been made, duly seconded. Darlene, would you call the roll?
Representative Perry.
Yes.
Representative Williams.
Yes.
Senator Diamond.
Yes.
Representative Martin.
Yes.
Representative Bryant.
Yes.
Representative White.
Yes.
Representative O'Connell.
Yes.
And Representative Seabra.
Yes.
Okay. 4, 6, 8 in the affirmative, and there are 5 absent.
Thank you, Darlene.
You're welcome.
Well, folks, this concludes our work for today. Senator Diamond, any closing comments?
No, thank you for carrying on in such a admirable way, which is no surprise given all your experience, but thank you for that. I appreciate you allowing my departure, and I thank you.
Well, I appreciate your turning over the gavel tonight. Now I need to put ink in my printer so I can read this here. Any other questions or comments? Seeing none, great job, guys. We'll see you Thursday at 1.
Have a good day, everybody.
Have a good day.
See ya.
See you later.